Due process of law. Our current legal system is scamming us. Do you want to find out how? The bait and switch. Lawyers, attorneys, and judges will tell you that our current legal system is performing due process of law. The current legal system is not using due process of law as it was originally intended. It has been flipped upside down. Let's see if our law dictionaries, constitutions, and historical writings will agree with the lawyers or show them to be in error. Let's see what due process of law means. Due process of law in each particular case means such an exercise of the powers of the government as the settled maxims of law permit and sanction, and under such safeguards for the protection of individual rights as those maxims prescribe for the class of cases to which the one in question belongs. Law of the land, due course of law, and due process of law are synonymous, which means they all mean the same thing, and maxims of law are fundamental principles. The law of the land means due process of law. By the law of the land is most clearly intended the general law which hears before it condemns, which proceeds upon inquiry, and renders judgment only after trial. Everything which may pass under the form of an enactment is not the law of the land. It means due process of law warranted by the Constitution, by the common law adopted by the Constitution, or by statutes passed in pursuance of the Constitution. And pursuance means in following or to follow. So statutes passed in pursuance would mean a statute that is written to support the common law or the bills and declarations of rights. Enactment means, if you take the root word enact, it means to establish by law, to perform or effect, to decree. The common introductory formula in making statutory laws is be it enacted. And the word enactment means the method or process by which a bill in the legislature becomes a law. And let's review what law of the land means. And this is a portion of the definition. Everything which may pass under the form of an enactment is not the law of the land. So you can see an enactment is done by the legislature. It's also called a statute or a statutory law. And in the definition of law of the land, it tells you that an enactment is not the law of the land. Historical significance. William Blackstone. He was an English judge and law professor that wrote the 4-volume Commentaries on the Laws of England. Blackstone's commentaries had a major influence upon the Founding Fathers and their writings of the Declaration of Independence, constitutions, and the establishment of our legal system. Blackstone on the law of the land as common law. He said, and in those of our English courts wherein a reception has been allowed to the civil and canon laws, if either they exceed the bounds of that reception by extending themselves to other matters than are permitted to them, or if such courts proceed according to the decisions of those laws, in cases wherein it is controlled by the law of the land, the common law, in either instance both may and frequently does prohibit and annul their proceedings. Blackstone distinguishes common law from statute law. He said the municipal law of England, or the rule of civil conduct prescribed to the inhabitants of this kingdom, may with sufficient propriety be divided into 2 kinds, the lex non scripta, the unwritten or common law, and the lex scripta, the written or statute law. Blackstone on statutes and the common law. He said statutes also are either declaratory of the common law or remedial of some defects therein. Now let's review the law of the land definition. It means due process of law warranted by the Constitution, by the common law adopted by the Constitution, or by statutes passed in pursuance of the Constitution. Pursuance means to follow or following. So Blackstone stated that the statute should either be declaratory of the common law, which means they should state the common law or be in support of the common law, or provide a remedy that the common law did not. And in the law of the land definition, the statutes should be in pursuance of. So the same thing, it should be in support of the common law, or it should provide a remedy that the common law did not. Affirmative statute definition. A statute couched in affirmative or mandatory terms, one which directs the doing of an act or declares what shall be done, as a negative statute is one which prohibits a thing from being done or declares what shall not be done. Blackstone describes affirmative acts of Parliament as those wherein justice is directed to be done according to the law of the land. And remember, law of the land is referring to common law. And in America, the phrase in pursuance of the Constitution means that, or in other words, in pursuance of the common law. And you can see that this is referring to Black's Law commentaries, which is referred to a lot in our law dictionaries. Zephaniah Swift, he is the author of America's first law book. He said, the deity, having from all eternity established the general laws that will operate with invariable certainty through all eternity. He is capable of foreseeing all events that will take place, and of course, all things past, present, and to come are forever in the view of his omniscient mind. These general laws, resulting from the original principles and fitness of things, and applicable to animate and inanimate matter, and rational and irrational beings, are denominated the laws of nature. Law of the land and general law. The law of the land definition, according to Black's Law, 4th edition, stated, by the law of the land is most clearly intended the general law which hears before it condemns, which proceeds upon inquiry and renders judgment only after trial. So the law of the land equals the general law. And according to Black's Law, 4th edition, general law means a law that affects the community at large. In Zephaniah Swift's first American law book, it states, these general laws, resulting from the original principles and fitness of things, and applicable to animate and inanimate matter, and rational and irrational beings, are denominated the laws of nature. So he equates the general law with the laws of nature. The laws of nature equals God's laws, which equal common law. Lex terrae. This is a Latin term found in our law dictionaries. It means the law of the land, the common law, or the due course of the common law, the general law of the land, equivalent to due process of law. That's from Black's Law, 4th edition. Synonymous. Due process of law, due course of law, and law of the land are all synonymous and refer to common law, which are the laws of nature, God's laws. The Founding Fathers wrote down some of these common laws and called them the Bills of Rights or Declaration of Rights, as shown in our constitutions. Common law comes from God. Under common law, you are innocent until proven guilty of causing injury or harm to someone. Statutory law is created by legislators. Under statutory law, you are considered guilty and must prove your innocence. Constitutional examples. So this example is from the Connecticut State Constitution, Article 1, Section 8, which is from their Bill of Rights or Declaration of Rights. In all criminal prosecutions, the accused shall have a right to be heard by himself and by counsel, to be informed of the nature and cause of the accusation, to be confronted by the witness against him, to have compulsory process to obtain witness in his behalf, to be released on bail upon sufficient security, except in capital offenses where the proof is evident or the presumption great, and in all prosecutions by information, to a speedy public trial by an impartial jury. No person shall be compelled to give evidence against himself, nor be deprived of life, liberty, or property without due process of law, nor shall excessive bail be required, nor excessive fines imposed. No person shall be held to answer for any crime punishable by death or life imprisonment unless upon probable cause shown at a hearing in accordance with procedures prescribed by law, except in the armed forces or in the militia when in actual service in time of war or public danger. Here are some state examples showing due course of law and the law of the land. So in the Indiana State Constitution, Article 1, Section 12, entitled Openness of the Courts, Speedy Trial, it says, all courts shall be open, and every person, for injury done to him in his person, property, or reputation, shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. And in the Delaware Constitution, Article 1, Section 7, procedural rights in criminal prosecutions, jury trial, self-incrimination, deprivation of life, liberty, or property, it says, in all criminal prosecutions, the accused hath a right to be heard by himself and his counsel, to be plainly and fully informed of the nature and cause of the accusation against him, to meet the witnesses in their examination face to face, to have compulsory process in due time on application by himself, his friends, or counsel for obtaining witnesses in his favor, and a speedy and public trial by an impartial jury. He shall not be compelled to give evidence against himself, nor shall he be deprived of life, liberty, or property, unless by the judgment of his peers or by the law of the land. I don't think that happened for our January 6 prisoners. The Florida State Constitution, Article 1, Section 9, on due process, it says, no person shall be deprived of life, liberty, or property without due process of law, or be twice put in jeopardy for the same offense, or be compelled in any criminal matter to be a witness against oneself. And the United States Constitution, Amendment 5, and the amendments are the Bill of Rights for the U.S. Constitution. It says, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. In the United States Constitution, Amendment 7, it says, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. And all of these are located in the Bill or Declaration of Rights section in the Constitutions. Trial definition. I found this quite interesting. The definition is a judicial examination in accordance with the law of the land of a cause, either civil or criminal, of the issues between the parties, whether of law or fact, before a court that has jurisdiction over it. And accordance means in agreement or conformity. So it says accordance with the law of the land. The law of the land is the common law. So a trial should be by common law. Summation. Due process of law, due course of law, and law of the land are all synonymous and belong to the process under the common law. The process was set up to safeguard our individual rights. General laws are also known as common law or laws of nature. Laws of nature are God's laws. The Bill and the Declaration of Rights are common law, God's laws. Enactments or statutory laws are not the law of the land. Trials for we the people should be done in accordance with the law of the land, common law, the Bill of Rights, not statutory processes. Statutes are for government personnel, not we the people. The question should be, did we violate another's rights as outlined in the Bill and Declaration of Rights? No person shall be deprived of life, liberty, or property without due process of law, which is the common law. Under common law, we are innocent and remain free until proven guilty. We have a right to meet our accusers face to face and to obtain witnesses on our own behalf. We have the right to a speedy and public trial, and conviction should only be by an impartial jury of our peers. Judges are our trustees. They work for us. They are not over us, as the people have all political power. Currently, our judicial systems uses statutory laws against us, not common law, and calls it due process of law. Historical usage and definitions clearly show that due process of law, the law of the land, or due course of law is referencing common law, which is our bills or declarations of rights, not statutory law. We have been scammed. In 1 Thessalonians chapter 5, verse 21, it says, "Prove all things, hold fast that which is good." It seems, instead of taking what lawyers and attorneys say at face value, we need to check and make sure what they say is actually true. William Blackstone. He was a substantial influencer on the Founding Fathers and the laws they established in America. He said, "No enactment of man can be considered law unless it conforms to the law of God. Man must be subject to the laws of his Creator. This will of his Maker is called the law of nature. This law of nature is superior to any other. No human laws are of any validity if contrary to this." Thomas Jefferson, he was the principal author of the Declaration of Independence, and he said, "A free people claim their rights as derived from the laws of nature and not as the gift of their chief magistrate." And a magistrate is a public official, as in a legislator. So what he's saying here is that our rights come from God. They are not given to us by the legislator. So the legislators do not have jurisdiction over us, nor can they write laws over us. Thank you for watching. Please like, subscribe, and share this video with others. I'd like to tell you about Yeshaya's herbals. Herbs are God's medicine to bring about healing for various ailments and diseases. Herbs are natural, organic, and effective. In Ezekiel chapter 47, verse 12 in the Bible, it tells us that the leaf of the tree is therefore for medicine. And it also tells us in Revelation 2 that the leaves of the trees are for the healing of the nations. Yeshaya provides many different products for various diseases and ailments, including neuropathy, healthy heart, herbal iron, which gives you a wonderful boost of energy, cholesterol issues, allergies, lung blend, parasite cleanse, and much more. Please go to her website at yeshayasherbalspma.com. If you place an order, you may use the code TruthTornado in all capital letters all together when ordering to get free shipping on your first order. Please go and check out her website and her products. Thank you very much.